Good morning, everyone. Welcome to another lecture organized by the Legislation and Legal Opinion Commission. Today's lecture is about the adoption of English language proceeding before Bahraini court. Our speaker today is Judge Zain Hassan Al Asfour, judge at the High Civil Court. Thank you for joining us. And now I would like to invite Judge Zain Hassan Al Asfour to begin the lecture.
Good morning, everyone, and thank you for this introduction. I would also like to thank the Legislation and Legal Opinion Commission, the LLOC, for organizing this lecture, which is a part of a series of lectures. And I do hope that the audience will find this lecture beneficial and fruitful. Today, we will be talking about a significant development in the Kingdom of Bahrain's legal landscape, which is the adoption of English language proceedings before Bahraini courts. This is an overview of what we will be covering today. Firstly, we will talk about the legislative foundation and overview of the adoption of English language before court. The second, we will be talking about the driving forces behind Bahrain's adoption of the English proceedings. So what made the Kingdom of Bahrain undertake this measure and adopt the English language before courts? Later on, we will move to the legal framework governing the English language used before courts, which is the ministerial resolution of the year 2023, in specific Articles 1 to 6. And before concluding, I will personally shed light on the fifth and the most recent English judgment issued by the Court of Cassation. First of all, this significant legal development was rooted in the amendment of the Judicial Authority Law, to be specific in Article 4. So prior to this amendment, Article 4 stated that the only language to be used before court was the Arabic language, since it is the official language in the Kingdom of Bahrain. However, with the amendment of the Judicial Authority Law, which happened by Legislative Decree number 27 of the year 2021, which gave the parties an option to agree on the language to be used before courts. In addition to that, the amendment of the Judicial Authority Law mandated the Ministry of Justice, subject to the approval of the Supreme Judicial Council, to issue a resolution to determine the court language to be used, in addition to the regulation of the scope and conditions of the foreign language to be used before court. During 2021, Ministerial Resolution number 117 of the year 2021 was issued by the Ministry of Justice, stating that the English language shall be used before the courts. However, a new resolution was issued, which is Resolution number 28 of the year 2023, that was issued on 6th of March 2023 and published on 9th of March 2023. And entered into force the following day. Moving on to the second content, which is the driving forces behind Bahrain's adoption of English proceedings. So, in other words, what made the Kingdom of Bahrain move and undertake this measure, which is the adoption of English language before courts? So, the main reason for the Kingdom of Bahrain's amendment is that is reducing the burden and cost of translation. So with the adoption of English language before courts, this will eliminate the need for costly certified translation of all commercial documents. So let's just imagine a case that will be adjudicated in Arabic. There are like thousands and thousands of documents that needs to be translated to Arabic. So this adoption of English language will definitely eliminate the need for costly certified translation. In addition to that, it will reduce delays because the translation of the documents will need lots of time to do that. Furthermore, it will minimize the risk of translation errors or discrepancies that may affect legal outcomes because some words may have different meanings. In addition to that, due to the reduction and the burden of cost of the translation, it will lower the overall litigation costs for the parties and businesses itself. In addition to that, speedy justice will definitely be achieved since the judgment will be issued in a faster manner due to the fact that the parties will not need to translate the cost, to translate the documents. This is also in line with the Kingdom of Bahrain's judiciary vision, which is the speedy justice, and it just, of course, take into consideration all aspects of litigation, such as fairness, granting the parties time to exchange memorandums and defenses, in addition to issuing judgments with good quality. Second of all, globalization and strategic position of the Kingdom of Bahrain. With globalization, the world has become more interdependent and international commerce increased. And with the increase of international commerce, of course, international disputes will definitely also increase. Due to the fact that the Kingdom of Bahrain has also a strategic location, as it occupies at the heart of the Gulf region, serving as a gateway between regional and international markets. This positioning also facilitates cross-border commercial activity and trade. And just to prove that, the Kingdom of Bahrain is also home for lots of international companies. As also a long-standing regional hub, Bahrain is also a long-standing regional hub for trade and financial services. Bahrain attracts also multinational enterprises, as mentioned, and this also attracts foreign direct investment within the kingdom. And it's something that's known that English is also used as standard in international transaction or international commerce. Third of all, Bahrain is a pro-arbitration, has a pro-arbitration legal environment. Bahrain has established itself as one of the region's leading arbitration-friendly jurisdiction, fostering a climate of legal certainty for international commercial entities. And this is because of multiple reasons. The main reason is that the Bahrain's arbitration law, which is law number 9 of the year 2015, is exactly a replication of the UNCITRAL model law on arbitration law. And we always say that if there's a mistake in the Bahraini arbitration law, there's a mistake in the UNCITRAL model law. So as the Kingdom of Bahrain adopted the UNCITRAL model law on arbitration exactly, this will reduce uncertainty. Furthermore, the Kingdom of Bahrain is also a party of the New York Convention on the Enforcement and Recognition of Foreign Arbitral Awards. Third of all, the Bahrain's judiciary supports arbitration, as a recent report issued by Reed Smith that I personally worked on, whereby data related to annulment cases and annulment applications were collected from the year 2018 until 2024, which states that only that 92.37% of the cases between 2018 and 2024 was rejected. So it definitely reflects that the Bahraini courts are consistent to demonstrate support for arbitration and the finality of arbitral awards that are issued. Second of all, some treaties that have been ratified by the Kingdom of Bahrain and the UNCITRAL model laws that are embedded within the Kingdom of Bahrain's national legislation are aligned with international law. And this alignment ensures that Bahrain remains a predictable and reliable jurisdiction for international business. And it reflects the Kingdom of Bahrain's commitment to harmonization with global commercial standards. So, for example, and not limited to, Bahrain is a party of the United Nations Convention on Contracts with International Sales of Goods, which provides a modern uniform regime for international sales. The Kingdom of Bahrain ratified the CISG during October 2014. As stated before, that the Kingdom of Bahrain also embedded the UNCITRAL model law on international commercial arbitration within its domestic laws, which definitely also ensures uncertainty. Third of all, the Kingdom of Bahrain also adopted the UNCITRAL cross-border insolvency within its national law regarding the reorganization and bankruptcy law. Third of all, Bahrain issued recently secure transactions law by law number 3 of the year 2026. And the Bahrain's secure transaction law is based heavily on the principles of the UNCITRAL model law on secured transactions law, which is definitely based on international best practices with modernized framework for security interest in movable assets and which enhances access to credit. And we are also happy to say that the Kingdom of Bahrain's commercial and civil courts are 100% paperless, which means it's fully digital, which enhances accessibility and transparency. Claimants or the parties may file the lawsuits electronically, and the proceedings will be handled electronically from electronic filing until the judgment is issued. So with that, it allows legal practitioners to submit claims, evidence, and motions through secure digital portal. In addition to that, case management is completely done electronically, which provides real-time tracking of proceedings, automated scheduling, and instant access to judicial orders, ensuring transparency for all parties. Third of all, we are also proud to say that the Kingdom of Bahrain has recently issued a system where remote hearings are held in. And this happened because a ministerial resolution has been issued by the Ministry of Justice, which parties, judges, litigants, claimant and defendant, and their lawyers or representatives, and the court clerk can enter, and parties can also share their documents. They can freely litigate before the remote hearings, and we also tried that, and it is a successful experience. And this is also aligns with global digital standards, facilitating international participation without the need to bear costs to come to the courts of Bahrain and appear before courts. Furthermore, there are available qualified Bahraini judges that are fluent in English, speaking and writing, and the Kingdom of Bahrain possesses growing cadre of judges and legal professionals with strong English language proficiency. This linguistic capability is a cornerstone of the modern digital system. In addition to that, this expertise supports the effective implementation of English language proceedings and ensures high-quality judicial outcomes that meet international commercial expectations. Lastly, we are also proud to say that the infrastructure of the Kingdom of Bahrain is ready to adopt the English litigation, since there is a published book with arbitration principles. All of the arbitration principles that are handled or that are actually laid by the Court of Cassation are published in 2 books, and they're also published in the Supreme Judicial Council's official website, whereby the principle is laid there, in addition to the summary of the relevant case. In addition to that, there are a translated judicial code of conduct is also published. Furthermore, we are also proud to say that there are translated laws to English. There are key commercial and civil laws have been officially translated into English. This accessibility allows non-Arabic speakers to directly engage with the legal framework governing their disputes. The Economic Development Board established a whole website whereby translated key commercial and civil laws are published there. In addition to the Legislation and Legal Opinion Commission, published also key commercial and civil laws in their official website. Moving on to the ministerial resolution regulating the adoption of English language before courts. So Article 1 stipulates the default English rule, which means that English shall be the language used before litigation, before the Bahrain Chamber for Dispute Resolution, the BCDR, if the contract in which the dispute arises from was stipulated or drafted in English. So this agreement is the basis for conducting proceedings in English, provided that the value of claim shall exceed 500,000 BDs, in addition to the applicability of the dispute category, be it if the dispute happened or occurred between licensed financial institutions, For example, if a dispute arises between two banks, or if a dispute arises between a licensed financial institution and a licensed commercial company subject to the Commercial Companies Act, or if the dispute between licensed commercial companies arising from their commercial relationship, which means that if the dispute arises from tort liability, which has nothing to do with their commercial relationship, the dispute will be adjudicated in Arabic. Lastly, if the dispute was related to international trade involving financial institutions and or commercial companies. However, the ministerial resolution also gave the parties an option to opt out of this route, which is using Arabic language if the following categories and requirements was met in the case. Parties can opt out of the use of English language before the claim is filed. And this happens if the parties jointly agree in writing to opt out of English before the claim has been filed. It is also vital to state that if the contract was drafted in more than one language, be it English and Arabic, English will not automatically prevail and the English language will not be used before the courts automatically unless if the contract states that the English language shall prevail. Second of all, English language will be used in arbitration-related court proceedings, as stipulated in Article 2 of the Ministerial Resolution. So English is the language of proceedings when the language of arbitration used is English. However, other requirements shall be met in order to use English language before the courts in arbitration-related cases. So with regards to cases related to appointment or challenging arbitrators, the contract shall exceed 500,000 BDs. With regards to cases related to interim or provisional measures, the claim must exceed 500,000 BDs. An example of cases where cases related to interim or provisional measures, whereby the English language will not be used. For example, if an emergency order has been issued or an emergency judgment has been issued by an arbitrator, and where the arbitrator used the English language within the arbitral proceedings, and the emergency judgment was related to stopping the enforcement of judicial files in a certain jurisdiction, and the interim measure was related to that. So the parties filed a case related to enforcing an interim measure relates to the stopping of enforcement of the enforcement file. Due to that, the value of the interim measure may not be valued by the court. Therefore, it will not. So the general principle will be applied, which is using Arabic language to hear the case, and the judgment will also, or the order will also be issued in Arabic, due to the fact that the claim was not above 500,000 BD. Third of all, if a party filed a case regarding enforcing an arbitral award, the case will be heard in English if the award was above 500,000 BDs. In addition to that, if the language of arbitration was also in English. With regards to cases relating to setting aside or the annulment of an arbitral award, the court will also hear the case and issue a judgment in English if the award was above 500,000 BDs and if the language used in arbitration was in English. Article 3 stipulates that the party may agree to use English before the courts if a document or contract is drafted in a language other than Arabic, and if the claim threshold was above 500,000 BDs, provided that the choice of English must be expressly stated in the contract in which the dispute arises from, or any correspondence between the litigants, or in a separate agreement that shows the party's intention to use English before before the Bahraini courts. However, other categories must also be applicable in order for the court to hear the dispute in English. First of all, if the disputes involve at least one foreign company, for example, if a company has been established in a foreign country outside the Kingdom of Bahrain, disputes related to shares, bonds, and other securities, disputes related to commercial papers such as checks and promissory notes, disputes related to trademarks, commercial agencies, and intellectual property rights, arbitration or mediation in commercial contracts, maritime, air transport, and carriage contracts, disputes relating to construction contracts. Article 4 stipulates a translation requirement. So parties must provide a certified translation of all documents submitted to the court if they are drafted in language other than English. This ensures accuracy and legal validity in proceedings. So according to my experience, all cases that have been heard by the courts in English, no translation was needed because originally all documents were drafted in English. So this is also in line with the Bahrain's driving force. So what made the Kingdom of Bahrain adopt the English language before courts is to reduce burden costs related to translation. This requirement, which is the requirement of translating documents, applies comprehensively to all evidentiary materials, such as contracts, correspondence presented as part of the legal proceedings, and all necessary documents related to the case and that are needed to settle the dispute. With regards to interpreter services, the court shall hear the parties or witnesses who do not speak English through a qualified interpreter, ensuring that language barriers do not impede the right to a fair hearing. Before that, the interpreter must take an oath or make a formal declaration confirming that the interpretation provided will be accurate, impartial, and truthful throughout the proceedings. Article 5 of the Ministerial Resolution stipulates the scope of application of Articles 1 to 4, which applies comprehensively to all related legal actions. For example, interventions by third parties in a case that was handled in English, joinder of parties to a case, applications and requests related to the subject matter of the original claim, counterclaims filed within the proceedings, other claims connected to the original action. This ensures that all of the case will be handled in English and not a part of it will be handled in Arabic and the other part would be handled in English. Lastly, Article 6 stipulated that the language of appeal proceedings. So if a judgment or court order has been issued in English within the first degree, any appeal therefore shall be conducted in English. So all levels of appeal and all levels of review. So if a judgment has been issued by the first degree court was in English, therefore the High Court of Appeal and the Court of Cassation will also hear the judgment in English. And it is also vital to state that there is a specific division that has been established to hear judgments in English, which is the High Court of Appeal. I will also now explore the Court of Cassation's fifth English judgment, which is the most recent English judgment that has been issued. The judgment has been issued on 11th of May, 2026, which affirmed the key principles of international commercial arbitration. The judgment upheld the finality and validity of an arbitral award and dismissed an action seeking its annulment. The judgment also indicated that foreign law invoked before national courts is treated as a matter of fact, and therefore the party relying upon it bears the burden of providing its content and applicable provisions. If the party fails to do so by proving the content of the foreign law, therefore the Bahrain's judiciary will apply the national law, which is the Bahraini law. The judgments also reaffirmed the separate legal personality of the company from that of its shareholders, whereby shareholders will not be liable unless the corporate veil is pierced. In addition to that, the judicial review in annulment proceedings is limited to determining whether statutory grounds exist. It does not extend to reconsidering the merits or reassessing evidence, which is also stipulated in the Kingdom of Bahrain's arbitration law, which is in line with the international arbitration law. To conclude, so far the Bahrain had a successful experience with regards to adopting English language before courts, and this is because the Kingdom of Bahrain established a comprehensive legislative foundation from the amendment of the Kingdom of Bahrain's Judicial Authority Law, which is Article 4, to the Ministerial Resolution number 28 of the year 2023, which provides a clear and structured framework for English language proceedings. And this is also due to the institution readiness with qualified English proficient judges that are fluent in both English and Arabic, reading and speaking. We have the Kingdom of Bahrain has a fully digital court system. There are translated key commercial and civil laws and codes. And in addition to that, all arbitration principles are fully codified, translated and codified in a book that is also published within the Supreme Judicial Council's official website. Bahrain also possesses the institution infrastructure to support English litigation effectively, with also lawyers, professional lawyers that can also handle cases related to or cases that are international of nature, in addition to cases that are handled in English language. The adoption of English language proceedings reinforces Bahrain's position as a legal international dispute resolution hub, attracting foreign investment and aligning with global commercial standards. Thank you. أستاذ أنس أنت ميوت.
Thank you, Judge Zain Hassan Al Asfour, for today's lecture. On behalf of the training team of the Legislation and Legal Opinion Commission, we would like to thank everyone who joined us today. We hope to see you again in future lectures. Thank you and goodbye.